going live for a weekly Q&A. Thank you for joining me again. My name is Kristen Romance. I'm the estate planning mom, and today I am going to be answering your estate planning questions. So if you have any questions relating to wills, trusts, guardian nomination, what happens when somebody passes away with their estate, how title is held to property and how that's affected, please make sure to put those in the comments, and I will try to get to them. So I have compiled a list of probate questions that I have received recently, and I think it's really important for people to understand the impact that probate can have when somebody passes away on an estate and on the family, and I want to go through those questions specifically. So we are talking all about probate today, all things related to when somebody passes away, how their estate is distributed, how beneficiaries receive stuff, what are costs associated with it, how long does it take? And remember, I am licensed in California as an attorney, so everything that I'm talking about today is specific to California. Our office is located in Ventura, Westlake Village, Santa Clarita. We also service clients virtually throughout the state of California. So we really do see clients all over the state through, especially right now with everything being virtual, we are seeing all of our clients either over the phone or through Zoom to be able to do our design meetings and estate planning, what we call our family planning assessments. Okay, so if you have any questions, again, please make sure to put those in the comments and questions. If you don't feel comfortable posting a comment or a question, you can always email us. It's info@hermanslaw.com, or feel free to send me a private message. You can also get lots of information. I have tons of videos, tons of blog posts, free printables, tons and tons of free printables on our website, www.hermanslaw.com. It feels funny saying www. I don't know if anybody ever says that anymore, but now that I say it, I don't like saying it. So I'm just going to say go to hermanslaw.com going forward. And as always, you can feel free to send us messages either via text or calling our office, 805-518-9633. Hey, thanks for joining. So if you have any questions, please make sure to get those comments on however you're watching this, and I will try to get to those. But we're going to start with probate. Again, that's what we're going through today. So first one is relating to having a will and probate. And the first question is, if I have a will, does my estate have to go through probate? And the answer is yes. If you have a will, your estate still has to go through probate. So when you're listening to this, it doesn't just have to do with your stuff, right? You have family, right? You have parents potentially, or aunts and uncles, grandparents. This is all stuff that relates to them too, because you may be affected by it. So it's important to kind of think of it from that aspect as well, as from a family perspective in planning. So if you have a will, your estate still has to go through probate. A will does not prevent probate, and that is one of the biggest things I hear from people in when it comes to estate planning and them having documents in place. They'll say, oh, well, I have a will, so I don't have to worry about it. And that is not the case. Having a will just tells the probate court what to do with your stuff. It doesn't actually prevent the probate process. So that's why it's really important to understand that. The way that we prevent the probate process is by having a trust. And that is the planning that we do with clients, is setting up estate plans, including a revocable living trust. This allows you to hold all of the assets that you have, your house, checking accounts, any of your bank assets, things like that, in the name of your trust, so that if something happened to you, rather than their stuff being in your name personally, it wouldn't have to go through probate because it would be in the name of your trust, being distributed according to your wishes and what's in your trust. Okay, so next one, how long does it take to go through probate? Well, in California, and the courts that we work with most are Ventura and Los Angeles County, normal probate proceedings can take anywhere from 9 months to 2 years. And that's uncontested. And when I say uncontested, I mean there aren't beneficiaries that are fighting over things, right? This is just everybody is in agreement. It's just the process that it takes to get through everything. So this is the process that 9 months to 2 years can take. However, with everything that's going on, our courts have been shut down. And so it's taking even longer than that time period for people to have to go through probate. So I have a case in LA that we just filed for probate last month. And the initial hearing date is set for November, which means that we don't get to start anything in that case until November. So that's when the time starts moving along at that point. And so it's really important to know that when somebody has an estate that has to go through probate to be distributed to their beneficiaries, it's going to take that long for the beneficiaries to actually receive it. And the way that we prevent this is by doing a trust, a revocable living trust, like I mentioned. So we do this trust so that you have the assets that are held in your name, in the name of your trust. And then if something were to happen to you at your passing, rather than the stuff have to go through probate court, because that's what court would be doing, is you don't have any assets in your name. So it's distributing according to what is in your trust according to your wishes. And that's why it's so important. By having this tool, it allows your family to not have to go through this process. The same thing happens when you have family members that if they pass away, you would have to wait this whole time to go through this probate proceeding, this 9 months to 2 years, to actually receive anything from their estate. And the way that you prevent this is by doing a trust to have your instructions in place that would prevent this whole process. And so it really does cut down on that time that your family members would have to wait to get access to your assets, especially if they're relying on them, right? And when it's in probate, they might not have access to them. And so by keeping it out of probate, it keeps it private. It keeps the time down that it takes to actually get the assets to them. Okay, so if you're just joining us, thank you so much. Please post any questions that you have in the comments. Today we are talking all about probate and ways to avoid it. How much does it cost? How long does it take? What are some things to think about? Why should you try to avoid it? Because probate is not a great process to have to go through in California. And these are some of the questions that I'm going through. So if you have any comments, please make sure, or any questions, please make sure to put those in the comment section. If you do have any questions and you don't want to post it, please email us, info@hermanslaw.com. You can always go to our website. There's lots of information there. Hermanslaw.com is the website. And as always, feel free to call or text our office, 805-518-9633. Okay, so going back to our next question. So what is the cost of probate? And this is very mind-boggling to a lot of people because they don't really think about the impact it has at the size of your estate and how much it actually costs to go through probate. So probate costs are set by statutory fees by the state of California, and they are percentages based on the level of assets that you have. So a smaller estate would have less money that they would have to pay to cost because they have smaller assets. But larger estates, and if you own a home in California, it's a large estate, right? You know, median home value anywhere from $500,000. It's going to be a lot. So I want to break it down for you just to give you an idea of how expensive probate court actually is. So let's take a $700,000 estate. And when I say $700,000, it may seem like, wow, that's a lot of money, and it absolutely is. But what you might not think about is just the value of your home alone. So if you have a home worth, like, let's say $500,000 or $600,000, and then bank accounts, checking accounts, investment accounts, bonds, stocks, anything like that, that make up another, let's say $200,000. So then you're looking at about $700,000 for your estate. If something were to happen and you had all of these assets in your name, then they would have to go through probate court to be able to be distributed to your heirs. There's other stuff that goes into it, but that's basically what it comes down to, is paying any bills that are left over and then distributing the rest to your beneficiaries. So a $700,000 estate, meaning if you have a home, the fair market value, let's say it's, you know, anywhere from $500,000 to $700,000. Even if you have a mortgage and the house, you don't have that much equity, it's still that amount of money that fair market value of that house would cost is the amount that it's going to be put at from an asset level. So again, $700,000. So the first $100,000 of that $700,000 is 4% is going to attorney's fees. And again, these are set by statute. So that's $4,000. The next $100,000 is 3%. So that's $3,000. The next $500,000, because we're going up to an estate worth $700,000, is 2%. So that's $10,000. So you're looking at a total of $17,000 that's going to attorney's fees. And this is, again, set by statute. It's not like we're saying this is how much money you have to pay. This is set by the court statute. It could be more, but that's the baseline for what these statutory fees are. But that $17,000 isn't all. There's another $17,000 that's paid to the personal representative. So the person that actually administers the probate proceeding of going through that whole process gets paid $17,000 as well. So you're looking at $34,000 that would go in probate costs or probate fees. And costs on top of that you have to add in. So let's just say very basic $2,000 to cover filing fees, bonds, the end filing fee, and any of that kind of stuff. So let's say, so you're looking at $36,000 for an estate to have to go through probate if the estate has a value of $700,000. So you can imagine if you have an estate over $1 million, that's a lot of money. If you have a estate of $500,000, you're looking at $28,000 in probate fees. Okay, and this isn't just for you, right? If you have family members, if you have parents, grandparents that have this, where they have a house in their name, and you want to prevent this, this is money that literally will come out of your inheritance, your family's inheritance, your kids' inheritance. All of this money is just getting paid to fees, and it can be avoided by putting a trust in place. A revocable living trust allows you to put all of these assets into your name as you as the trustee of your trust, so that it's held in your trust. So that if something happens to you, rather than your stuff having to go through probate court, it goes through your trust and is administered according to what your trust wishes say. Okay, and that's what we try and do, is we try to avoid this probate process because it is so expensive, because it is so time consuming, right? And it's public. It's one of the other things I wanted to mention. Probate proceedings are public, meaning anybody can go down to the courthouse, find out what you own, who you owe money to, and who your beneficiaries are. So if you are a private person and you want to keep your stuff private, if your estate has to go through probate, anybody can go find out what you have. You see it on TMZ all the time. When a celebrity passes away, somebody from TMZ will go down to the courthouse, pull the documents, and find out what's in their will, or if they didn't have a will. I'm thinking of a few celebrities off the top of my head, like Prince, didn't have a will. Aretha Franklin, still trying to figure it out, but potentially didn't have a will or has a will. Luke Perry, he had a trust. Nobody has any idea what's going on with his estate because it's private, right? It's all within the trust. So these are things that we hear, like when celebrities pass away, and this is what it means for people to be able to have that privacy, is by doing a trust. Okay, let's talk about minors. How are minor children affected? And if you're just joining us, if you have any questions about probate, that's what I'm trying to focus on today, because there's been a lot of questions that have come up recently about it. Please make sure to post your comments or questions in the comment section, and I will try to get to it. If you do not want to post your question, you want to send me a message, please send me a personal message, or you can always email us info@hermanslaw.com. Go to our website, hermanslaw.com, to be able to find any of the information that we have out there. I have a ton of free printables. I just put up a beneficiary tracker. So if you need to go through and figure out what accounts do you have, what retirement, what life insurance, what checking accounts, all of those kind of things. This is a tracker for you to be able to track that and then figure out, who do I have listed as beneficiaries as the primary, who do I have listed as a backup, because it's a really great exercise that I find a lot of people, they lose track, right? Stuff comes up over time. Maybe you got a retirement account before you got married, and then you got married and it's 10 years later, and your parents are still listed as your beneficiaries on that account because you had it prior to getting married. So this is a really great exercise to go through this, and this free printable, it's on our website, hermanslaw.com. If you go to the resources up at the top, you'll see all the printables that we have. You can use this as an exercise to be able to go through and start organizing your stuff. Okay. And as always, if you have any questions, call or text our office, 805-518-9633, and we'll be happy to get a meeting set up. We do have free 15-minute phone calls available. So if you are interested, just to get some information, right? No obligation, it's free, 15 minutes on the phone call to kind of understand what the process is. What are the next steps? We can book an appointment for you at that point if we need to. Hey everyone, thanks for joining me. So, next question is relating to minors. So how are minors affected with probate court? So minors are any child that's under the age of 18 is considered a minor. And it's really important that if you have minor children, that they're cared for in your estate planning documents. The number one reason why is without having any documents in place, right? And we do this as guardian nominations is what we call it. Without having any guardian nomination in place, if something happened to you and the other parent of the child, the court has no idea who you would want to raise your kids, okay? And that's why it is so important to remember that and know that you need to get something in place, because without it, the court makes the decision based off of what they think is best for your child, not what you want, because there's nothing legally in writing. If something were to happen to you and the other parent, then family members generally would petition the court for guardianship of your children. And it may be somebody that you would want. Maybe you've had a conversation with them. They know that you would want them to do that, and they did it. But what if there was somebody that petitioned the court that you would never want, right? The court doesn't know that you wouldn't want them because you never put it legally in writing. And so then you almost have this custody battle going between somebody that you really wanted and somebody you would never want. So that's why it's so important for you to put in writing legally who you want to be guardians of your children, so that if something did happen, the court would know what your wishes were. Because again, without it, they're making that choice without you having any input at all. And that's why it's so important. The other side from a guardianship perspective that, or from minors that I wanted to talk about in probate, is that minor children in the state of California can't actually receive money or property over a certain value, and it's not that much. So if you leave money to your kids outside of a trust, just that, you know, something happened to you and that money went to them, they actually couldn't receive it until they were 18 years old, which means it would have to go through the court system until they were 18. And then when they turn 18, they get all of it in one lump sum. I had a mom that I was talking to where she had a life insurance, or her husband had a life insurance policy, and he had recently passed away. And he had left the life insurance policy for whatever reason to the kids, the 3 little girls that were minors. And the mom at the time didn't know that he had done this and didn't find out until he had passed away. And she actually couldn't get the money. She had to go through court to be able to get that money for the benefit of the kids. And it was a very large life insurance policy that she didn't have access to. And so those are just, you know, those are reasons why having specific documents in place, having those legal plans, estate plans, and more specifically a trust, where you can actually say that if something happened to you, your estate would go to your kids according to your trust instructions. So rather than receiving everything at 18, they would receive it at ages that you set, maybe 25, 30, and 35, really being able to expand that time period that kids would receive something if something happened. So they're not getting it all at one lump sum when they turn 18. At that point, they're probably not financially mature enough to be able to receive that money and make the right choices. I heard a very scary statistic recently that said that 95% of people that receive inheritances, the inheritance is gone within 3 years. And so if you have an 18-year-old child that receives $1 million life insurance policy, can you imagine what 3 years of $1 million would do to that child? It's probably not the best, right? So by setting up the plans, like again, the revocable living trust that we do for clients, it's you being able to say, this is what I would want, and this is how I would want them to receive that money. Spreading it out over a period of time rather than receiving all of it at 18 years old, which is what would happen with no plan in place at all. Okay. If you're just joining us, please make sure to post any comments that you have. I'm trying to answer questions relating to probate because I have seen that come up most recently. And there's just really a lot to try and, you know, give you the information to make sure you know how to avoid probate court. Because probate court, again, it's a very long process. It costs a lot of money. If you weren't with me in the beginning, if you have a house in an estate worth $700,000, you're looking at probate fees adding up with court costs and fees, looking at about $36,000 to go through that whole process. And that's money that literally just gets taken right out of your beneficiary's inheritance from not receiving that money because it is so expensive to have to go through probate in California. So we work with clients to try and prevent this, right? One of the biggest things for us is avoiding probate court and making sure that if something happened to you, your stuff is distributed according to your wishes to the people you would want it to. So if you have children and you would want them to get the money, it's getting that trust in place that if something happened, distributing it to them according to your wishes, you know, whether it be, you know, 25, 30, and 35, or being able to pay for college or buying a house or whatever it is, we can do that within the trust. You do things when you don't have a plan in place and it has to go through probate, then you don't have that control. You don't have those specific instructions of how you would want your stuff distributed. And that's why this is so important. Okay. That is all I have time for today. I don't see any other questions that have come in. So again, if I wasn't able to get to your questions, please email us, info@hermanslaw, and I will be happy to help you with any questions that you have. Again, go to our website, hermanslaw.com, and you can get information, tons and tons of information on our website. I have lots of blog posts that talk about different things. If you can't figure out who to name as guardians, and that is why you're putting this off, please do not let that be the reason you don't get guardian nominations in place. Please don't let that be the reason you are not getting your legal documents documented legally, because without any legal documents, nobody knows what your wishes are. And so by at least having something, it's better than nothing. Okay. And always, again, feel free to call or text our office, 805-518-9633, and join me here every Wednesday for estate planning questions and answers. Thank you so much again for joining me. My name is Krista Hermance. Have a wonderful day.